Good morning, miss. My name is Yu Shuyang and I come from China. As you instructed, I have finished watching the scenario video and today I will critically evaluate whether the law confers an appropriate balance in protecting the interest of the bank and the borrower at the same time. I will largely based on Brandon's situation and give him sound advice. I think this is a relevant topic that links to what is happening in the world now. In this COVID-19 pandemic, many property values are dropping and this resulted in these properties going into negative equity. At the same time, these small mortgagors had trouble to pay more or refinance just like Brandon. There are several issues to be discussed. Firstly, whether the top bank had a right of foreclosure. In advising Brandon on the issue of foreclosure, clearly this is one of the rights of the top bank, and according to Section 88 and Section 89 of the Law Property Act 1925, the statute confirms that foreclosure is one of the remedies available. However, due to its draconian nature, judicial precedents show that a mortgagee must obtain the court order before foreclosing a property. Similarly, mortgage agreement will usually exclude the right to foreclosure as soon as the legal date for redemption has passed. This is justifiable because it will be absurd and ridiculous when a mortgage property is being foreclosed just because of months of default in repayment. So the court action is naturally to uphold justice, and this gives the court an opportunity to grant for foreclosure nisi. The foreclosure nisi operated to protect the interest of the borrower by giving him a period of time to pay off the loan. Nevertheless, due to the existence of Section 91, subsection 2 of the LPA 1925, the court is more reluctant to allow the foreclosure action. The court is rather likely to order a sale in lieu of foreclosure. This is why the foreclosure actions are almost ahead of today, as held the Park and the Mortgage Service funding case. Applied to Brandon, when the Touch Bank wanted to request a foreclosure action on his property, he then was entitled to request for the sale because Section 105 provided that anyone interested would seek for the sale. Following a sale in lieu of foreclosure, Brandon may gain the surplus proceeds of sale, but having seen the Brandon's mortgage is upside down, the proceeds of sale are likely to have any surplus left available for him. If Brandon had any academic share available, such as living with his parents, then actually a foreclosure action is also a workable method for him to discharge his mortgage debt completely. This is because following a foreclosure action, to Top Bank rights to sue him for shortfall debit will be extinguished together with the mortgage debt. So I will advise Brandon that foreclosure was not always scary. In his situation, it could allow him to pay less. However, as the Park's case mentioned, the court has unfettered discretion to order for a sale. This would effectively put the matter in the court's head to let the court decide on whether or not to allow the foreclosure, since Brandon and his wife could continue generating income, but just merely not that much to service the debt. The court is likely to order sale in lieu of foreclosure to ensure that the bank could still sue the shortfall debt personally against Brandon. Next, I will advise Brandon on the issue of whether the bank could take possession of his property. According to Maids and Dudley Marshall case, the mortgage actually had the right to take possession even before the ink was dry on the mortgage. As we can see in Western Bank and Sinler, the court held that their right to take possession will still be existence even when the mortgage was defective. So the Touch Bank had the right to take possession, and it is a common law right, which means that he possesses as of right without the need to request for possession order through court proceedings. This was confirmed in the Ropage and Barclays Bank's case. However, we could see that nowadays many mortgage actually will go to the court to request for possession order instead of proceed as of rights, especially when the property is subject to possession was a residential house. This may be due to the fact that the UK Council had indicated that it is members would need to speak position before sale by court order. There be triggering Section 36 and the Administration of Justice Act 1930 and Section 8 of the Administration of Justice Act 1973. They effectively protected the mortgages becoming homeless. If the mortgage could simply possess the house at the right every time, then the consequence positions towards a mortgagor or whoever in Brandon's situation actually make no difference to the draconian foreclosure action. So by having these statutory positions, the current law protects the interests of the borrower in the sense that the mortgagor will be likely to be granted an adjournment. For example, the Supreme Court practice on this matter was automatically granted 2 years adjournment. In Cheltenham GBS and Grant, we could see the discretionary power of the court on this method by allowing the postponement of possession to give an opportunity to the borrowers to get on his feet again. On this issue, one may argue that the law only protects the interests of the borrowers and the statutory provisions operate at the disadvantage of the bank. However, this is not always true because the mortgage or the bank would also be very happy if the mortgagor or borrowers could follow the terms and repayment of the mortgage, since the mortgage at the end of the day could not earn any actual profit through the vacant position of sale pursuant to Section 105 of the Law Property Act 1925. They are more happy than the borrower or borrower could just stick to payment terms. There are also circumstances where the mortgage used this statutory protection to give pressure to the borrowers, even though the borrowers clearly don't have any money left. So in the sense, the current law also protects the mortgage or the bank and thus achieves a balance of interest. Applying to Brandon's situation, although the court may not allow the foreclosure action, but the court definitely also allow the possession order if he forced to pay within the reasonable fixed period of adjournment granted by the court. Having seen Brandon and his wife already took 3 jobs but still could not afford the mortgage debt, the Sections 36 and Section 8 means not help him much because it is less likely that Brandon would be able to take more jobs to earn money anymore. I think if he is employed now, then he will be more likely to get sympathy from the court because taking into consideration that the pandemic really caused a lot of employment and involuntary default mortgages. In that scenario, then the court is likely to give him more time to stand on his feet again. Therefore, I think the court will give him time but only a short period of adjournment and will not simply exercise the right to possess his property because in the normal course of events, the mortgage contract will exclude the right to seek possession unless the default on payments occurred like case of Isho Petroleum Co-Ltd. Lastly, selling of the property to recover the loan is the main objective of the top bank, so Brandon also needs to be advised on the issue of the extent of rights to sell by the top bank. Generally, the top bank could only sell his property when the right to sell arose and became exercisable. According to Section 101 of the LPA 1925, the 3 conditions provided under these provisions must be satisfied only the power of sale would arise. Firstly, the mortgage has been made by dead. Today, even the equitable mortgage would be encouraged to be made in deed form because deed form will imply the right to sell, so I will assume their mortgage in the deed form. Secondly, the mortgage money has become due. Thirdly, there is no contrary intention in the mortgage deed to exclude the power to sell. Since the second and third requirements were silent in the scenario video given, I will assume they were satisfied and thus the power to sell arose. Once these conditions have been satisfied, then Section 103 comes into play to make the power to sell become exercisable. There are three conditions under Section 101, but if there was anyone of satisfied, then the power became exercisable. For example, if the interest of the mortgage debt is in arrears for 2 months, then the power is exercisable. Since Brandon said the video that doesn't cut it, showing that his job would not be sufficient to pay for mortgage debt. I think the arrears become due is just a matter of time. Today, the current law no longer requires a transfer of estate in the formation of a mortgage. Nevertheless, it is important to note that the mortgage is able to sell not only estate he has, but also the estate vested in the mortgager. In addition, the mortgager can sell the estate even without a prior position to take place. This is like in the case of Horsham Properties and Clark and Beach. However, this case raises some tabas as it seems a failure to protect the interest of the borrower. For example, vacant position is more likely to sell the property at a high price. If a mortgage sells the land without ensuring the property was vacant, then the price obtained means not be true market value. In Kakmere Brick Co. and Mutual Finance Co., the court emphasized the duty of care owed by every mortgage was to ensure the property was sold at the true market value. According this to Brandon, yes, of course, the top bank could sell his property, but he need to worry that the bank would sell it as of right without position order and thus failed in triggering the Section 36 and Section 8 of the Administration of Justice Act because in most of the case, only vacant position is likely to reflect the true market value. Similarly, the Brandon need not to worry that the bank actually sells it at a lower value which doesn't reflect the true market value or simply gives discounts to the purchaser like in the case of Michael and Miller. If the top bank breached such day of care, then the top bank would need to pay compensation to Brandon. I think the power to sell conferred under Section 91 subsection 2 only protects the interest of the borrowers by ensuring their property will be sold at true market value. It also protects the interest of the bank in two ways. Firstly, as mentioned earlier, it will not extinguish the right to sue for personal convenience when the mortgage becomes upside down. Secondly, it effectively ensures that the mortgage will not be the treaty for the mortgager and thus the mortgage enjoys discretion in deciding the timing to sell on their own interest. Conclusively, the overall of the current law seems like achieving a balance. However, when a force majeure happens like the COVID-19, the law seems to prioritize the interest of the borrowers and not the bank. For example, the financial authority came with a series of measures in prevent the mortgage take the advantage of COVID to foreclose, to sell or possess the property of their client during the pandemic. Perhaps offer a capital repayment holiday to all the borrowers just like what is happening in the UK now. Although they would ensure that they still get to collect the interest from the borrower, but this law still largely operate on advantage to the borrowers only, especially those who had the financial ability to pay would take this grow the opportunity to borrow more at the expense of the bank. Other than such a force majeure, I will still agree that the law confer appropriate balance in protecting the interest of the borrowers and the bank.